Good morning. Happy Friday. We made it to Friday. Yay. So, Lane's attorney, Resnick, filed a motion to dismiss. Apparently, allegedly, they received the 100 plus hours of live streams that Lane did. Why you would do live streams about a topic as sensitive as what Lane made his videos about, i.e. the victim, is beyond me. Because these videos that I do are essentially live streams. Turn on the camera, talk to the camera, upload. No editing. I misspeak in these videos. I know I do because people call me out for it. But if you don't have a script and you're going to talk about something very sensitive over hundreds of hours, you're probably going to misspeak. You're probably going to stick your foot in it. You know what I'm saying? Like, it just boggles me how stupid Lane Myers was for doing all of this. But the defense, Resnick, was saying that, like, you guys didn't give us clear indications of where each alleged violation happened in these hundreds of hours of videos. And so they want to dismiss, or in the alternative, they want further clarification from the prosecutor of which exact sections of these hundreds of hours of videos are where the violations allegedly occurred. I don't see the judge dismissing based on this. I do see the judge saying, yeah, you need to give further clarification on what specific things you're alleging are violations. So, I think Resnick has a good shot of succeeding on that part of it, because that was the alternative relief he was asking for. But I would bet everything I own that it's not going to get dismissed. No guarantees ever. Judges make mistakes, but yeah, good luck. Good luck on the dismissal. In my video comments the other day, Stonk Dad, who is an ardent Lane Myers supporter, so he is definitely a sub 80 IQ retard, had a couple pithy comments that I figure I would address. I don't really like to address comments in the comment section, especially if they're going to require more than a sentence to resolve. So, someone, not Stonk Dad, said, and this is about as close to a quote as you can get without me having it written down in front of me. He said, "How can words be used against you if they're not given under penalty of perjury? How can words, not your words, just words generally, be used against you? Where? In court? Who knows? If they're not given under penalty of perjury." So I asked, is this a real question? Because, that's broad. Like, wow. Like, let me just walk you through law school. Let me walk you through 3 years of law school, plus some extra that you don't learn at law school in the comment section to explain all the legal reasons how words generally can be used against you in any situation if they're not given under penalty of perjury. And Stonk Dad comes back in hard, swinging hard. "Okay, first your family law attorney, man, I guess you can't do it." Or something to that effect. Okay, bro. If you sign a contract, you don't do so under penalty of perjury. And that contract can be used against you. If you say "I do" at a wedding to another person who is also saying "I do" back to you, your words of "I do" can be used against you in a subsequent divorce proceeding. Because without that "I do," you're probably not getting divorced. The difference between, let's say, assault with a deadly weapon and armed robbery are the words that you say after you point the firearm at someone. If you just point a firearm at someone, that's assault with a deadly weapon. Check your local variation, state law. But it's probably going to be called something very similar to assault with a deadly weapon. Once you say, "Give me your wallet," Now it turns into armed robbery. Those are your words that are going to be used against you. Now, what I think the original poster was asking is, how can your words, not just words in general. Oh, yeah, when the judge says guilty, when the judge says, I'm sentencing you to 10 years of hard labor, those are words, the judge is not under penalty of perjury when he's saying it, that are going to be used against you. But if we refine the statement to how can your words be used against you in court if they weren't given under penalty of perjury, that's an entirely different thing. So there's a thing called hearsay. Well, first of all, yeah, there's a thing called hearsay. Now, hearsay is an out-of-court statement, so a statement not made under penalty of perjury where you can't be cross-examined for it, that is offered into evidence for the truth of the value asserted therein, the truth of the statement asserted therein. So, if I say the sky is blue, that is a truth statement. I am saying a truth, it has truth value. Or actually, let's say I say the sky is green. Okay, that's still a truth statement. It's not a true statement, but it is a truth statement. It is a statement as to the value of something, as to the existence of something, right? I am making a claim, a truth claim. If I am not a party to that, if, let's say, the plaintiff in a civil case says, but John said the sky was green. Well, that is hearsay, because assuming there's no other hearsay exception that would apply, they're saying the sky was green because John said the sky was green, but I'm not in court. I'm not under oath. I'm not subject to cross-examination. So it would be hearsay, and the defense attorney could object to it based on hearsay and move that it be stricken. Words are hard. It's early. This is the whole thing about live streaming again. You misspeak. So hearsay is a specific rule to exclude specific things, right? If, for example, let's just stick to it. So, an exception to the hearsay rule is an out-of-court statement offered for the truth of the value asserted therein, made by a party opponent. So now, let's say the plaintiff said, John said the sky is green. If I am the defendant, there's no hearsay exception. It doesn't apply because the plaintiff is offering it against me as the defendant. So that is an exception to the hearsay rule. Now, as far as Lane's actions are concerned, they weren't, as far like the harassment, like he posted her address. It's not being offered as to the truth of the address. It's being offered as he is posting stuff about the plaintiff, or about the, we'll go back to the civil injunction against harassment. He's offering, or he's posting my phone number. I'm not bringing it up as to the truth of that, as to whether the phone number is my actual phone number. I'm saying that what he's doing is he is saying he's giving out my phone number. And he's asking people to call. Whether or not they call is a different thing. Whether or not he actually wanted them to call is a different thing. But he's telling people to call. Or he's insinuating people should call, I should say. I don't remember there was actually a claim that he specifically asked people to call her. Maybe he did, maybe he didn't. I don't know. It doesn't matter for the purpose of this education. But it's not being offered for the truth. But even if it was being offered for the truth, because Lane is the defendant, anything he says, I mean, you might be familiar with this from the Miranda warnings. I'm assuming that most Lane Meyer supporters have been arrested at least once and read their Miranda rights at least once, because they are sub-80 IQ retards, and sub-80 IQ retards tend to commit more crime. That's just facts. The dumber you are, the more crimes you tend to commit. and get caught for. Dumb people tend to get caught for their crimes because, like Lane Myers, they fucking post them on YouTube often. But anyway, so there's no hearsay. There's no way that you could object based on hearsay to anything that the state uses against the defendant, or a plaintiff uses against defendant, or defendant uses against plaintiff. Now, the state usually isn't. I mean, usually it's just their attorney talking, and you can't use the words of the attorney against the state at trial. So it's anything the victim said, since she's not a party to the criminal action, would not come in under a hearsay exception because she's not a party. So Lane can't say, "Oh, she said she wasn't harassed" or whatever. That would be hearsay, right? So unless there's some other hearsay exception that would apply. Because there are other hearsay exceptions, like there's a hearsay exception for business records. There's a hearsay exception. I mean, generally speaking, your state may vary, blah, blah, blah. There's a hearsay exception for excited utterances. Like an excited utterance would be like if I say fire and I'm pointing at fire and one of the parties wants to bring in, well, John said there was fire, but that would likely come in under excited utterance because, that's an exception. The underlying theory is that you're more likely to say true things if you're just reacting to it than, you don't have time to make up a lie about it. So it's more likely true. The hearsay rule is designed to keep out statements that have a low probability of being truthful, of being accurate. And so, excited utterance, courts have found that it's more likely to be true than not true if you say it as an excited utterance. So I hope that explains how Lane's statements can be used against Lane, even though Lane didn't make them under penalty of perjury, because there's no rule to exclude them. Generally speaking, anything can come in unless there's a rule to exclude it. There's evidence codes in probably your state. There's federal rules of evidence. I mean, there are rules that determine what stays out. If there's no rule excluding it, then it can come in. And just because something is stated under penalty of perjury doesn't necessarily mean it's going to get into evidence. A lot of people think that if they sign an affidavit or a declaration under penalty of perjury, that all of a sudden that is evidence that can be used at trial. And again, unless you're a party, it is probably not, because remember, hearsay, which would be excluded, is an out-of-court statement, and your declaration or affidavit signed under penalty of perjury would be an out-of-court statement offered into evidence for the truth of the value asserted therein. Most likely it would be offered for that purpose, for the truth of the statement contained in the declaration or affidavit, that was made out of court, where you weren't subject to cross-examination. And it's the cross-examination that is the big thing. It's not the penalty of perjury that's the big thing. It's the cross-examination that's the big thing. So you're more likely to get in statements made at deposition than a declaration. Both made under penalty of perjury, the difference being at deposition, you're subject to cross-examination. So it's more likely to come in. Again, check with a local attorney. Your state's hearsay exceptions might be different or whatever. And even deposition testimony, generally speaking, won't come in unless the deponent isn't available for trial. Because again, the court wants to see, the jury wants to see that person cross-examined at trial. So usually depositions only come in if the declarant is, or if the deponent is unavailable. And again, even declarations and affidavits could come in under certain limited circumstances, like if the declarant died, maybe it can come in. But I mean, all of these things are going to be subject to a ruling by the judge on whether or not it actually meets a particular hearsay exception. So I hope that answers that. The other dumb question or dumb statement that Stonk Dad made, I think it was Stonk Dad. I think he made both of these. I could be wrong. If I'm wrong, I apologize, Stonk Dad. You're still a sub 80 IQ retard. So he said, what is the difference between you calling everybody a retard and calling Lane a retard and what Lane did? You're just as guilty as Lane is. No. No. How about no? So these people look for the similarities and they don't look at the differences. And the differences is where all of the differences are. I am responding to things that Lane Meyer has said publicly on YouTube. He has broadcast these. He has published these. He has put these out there for public consumption. And I, as a member of the public, have a First Amendment right to talk about it. I have not addressed anything that he has not published. I'm not digging for his phone number. I'm not digging for his address. I'm not contacting him. I have never contacted Lane Myers. Lane Myers has called me multiple times. I have never contacted Lane Myers. I've never showed up at his work. I've never asked people to call flood him or to harass him. And Lane may not be a public figure. I would argue that he is a public figure if this came down to it, because he is a YouTube presence with a YouTube following, and he's putting his stuff out there on YouTube. I think he has made himself a public figure. But in addition, the matters that he's addressing in his videos and the matters that are being addressed at his trial are issues of public concern. And I, as a member of the public, get to comment on it. There's a world of difference between a public figure and covering issues of public concern over saying someone is a public employee, which has that's not a thing. I mean, it's not a thing as far as like First Amendment analysis is concerned. Saying someone's a public figure is just irrelevant. I mean, you could bang on about public figure all day long, every day, or public employee. See, live stream. Talking about public employees, it's a meaningless category. It has no legal relevance to whether or not you could criticize them and how you can criticize them and whether or not you can harass them or stalk them. All right, harassment and stalking. You can't even harass and stalk public figures, let alone public employees. I mean, you have a better chance of arguing that it's protected First Amendment activity with a public figure, a public official, than you would with a public employee, because a public employee does not kick in the extra New York Times versus Sullivan malicious, words just failed me. Actual malice standard in First Amendment review. So public employee is a meaningless category. So her being a public employee is completely irrelevant. Lane Myers being a public figure and Lane Myers' trial being a matter of public concern is relevant. So again, it's the differences that are important. In addition, I have not mentioned the names of public Myers supporters except for you, who was dumb enough to comment and raise the issues that I am now addressing. And you are a retard. Also, I am just broadcasting this. I'm not directing this. There are differences. There are differences. Oh, you mentioned my name in it. You're directing it at me. No. Now, Lane Meyer's situation is different because there is a criminal injunction or a criminal protective order, a civil injunction against harassment, and probation conditions, all of which say he can't do this. No such things apply to me. And this is why I am reasonably certain that you are a sub 80 IQ retard, because you can't fathom the differences. But let's just assume that what I am doing is exactly the same as what Lane Myers is doing. And let's assume that all Lane Myers was doing before he got the civil injunction against harassment was exactly the same as what I'm doing. Essentially, what you're arguing is that we both are harassing. So you're essentially giving up your position that Lane Myers wasn't harassing because you're saying I am harassing. Did you think about that? No, you didn't, did you? You didn't. Yeah, it didn't go through. Too much air between the ears. Too much air. Not enough brain. But again, what I'm doing is different than what Lane Myers is doing in a legally very important way. And you won't get that. And I understand it. So cope and seethe. Your boy played guilty. Thanks for watching. Have a great day.